Good afternoon, everybody. We'll go ahead and get started. I've asked Representative Matt Jackson if he would say a prayer for us.
Mr. Chairman, Heavenly Father, as we come before you, we ask for your mercy and your grace. Give us wisdom, give us leading, give us guidance as we enact the business of the people of this great state of Georgia. Bless our leaders, Father, in Jesus' name, amen.
Thank you, Representative. Today we got two bills. We're going to have a hearing only on Representative Buckner's bill, HB 1281. So what we're going to do today, Mr. David, we're going to go ahead and start with HB 1216 with Representative McDonald. And Representative McDonald, we're going to turn it over to you. I believe that's House Bill 1216. We're looking at LC 393124-EC. Is that what you got? Yes, sir. Okay. All right. You go right ahead. Let's see if we can find out which one we got.
Loud enough.
There we go.
All right. Thank you, Mr. Chair. Ladies and gentlemen of the committee, I bring you House Bill 1216. It's a public safety department bill that the governor's office is behind and dealing with the continued problem in our state of fleeing and eluding. We must do more to keep the citizens of Georgia safe on our streets and sidewalks. HB 1216 enhances the penalties that are already in place for those that choose to flee and elude law enforcement. We want to have these criminals that have a history of this practice to think twice, especially in the areas that have no chase policies. If you can look at some stats that I provided for you, that have been from 2015 to 2020 of stats that the Georgia State Patrol has been making, and but in 2019 we had a computer hack, so it is a little skewed there during that year. The main thing that 1216 you want to look at it has four areas that we've increased the conviction. The first conviction goes from 500 to 1,000. The second time that someone does this within a 10-year period goes from 1,000 to 2,500 and increases the days from 30 to 90 days incarceration. And then the third goes from 2,500 to 4,000 with a maximum of 5,000, and it goes from 90 days to 180 days. And then the fourth within that same 10-year period goes from 5,000 but no more than 10, and can have no less than 12 months, but no more than 10 years incarceration. Something also that House Bill 1216 does is changes the penalties that if you do like overtaking a stopped school bus with the signals out, emerging from alleys, building private roadways or driveways, laying drags. No driver or any motor vehicle shall operate the vehicle upon the public streets, highways, or private driveways or airport roads or parking lots in such a manner as to create a danger to a person, property, or intentionally and thus unnecessarily causing the vehicle to move in a zigzag or circular course or to gyrate or spin around except to avoid a collision, injury, or damage. What these changes are is taking it from a misdemeanor of fleeing to elevating it to a felony. Also, another change in this is on the last page where it states we're adding blue light to impersonating an officer. It used to be you could do it with your vehicle, motorcycle, but we're adding if you use that type of device of a blue light to impersonate an officer. I yield for any questions.
We have any questions? Yeah, we got one.
Thank you, Mr. Chairman. I just walked in, and so I apologize if you covered this in your introductory remarks, but how common is this? How big of a problem is it that we're working to try to address here?
I could show you back here and give you a stat sheet, and it'll answer that question for you. This is done in the metro area. Personally, I've ridden with the Nighthawks twice, and the experience, I got to challenge everybody. You ought to go out and do it on this committee, because the chases that we got in, the dangers that they put the public in, is, going racing down the different off the thoroughfares of Peachtree Road, getting onto I-75. It was an experience that I've never had before, and it's something that we have to do more to stop this.
Okay. That's it for now. Yeah, thank you.
Number 26.
Which representative, you talked about taking one of these acts from a misdemeanor to a felony. Which one were you saying? I didn't catch that.
One more time, sir. Your question?
You said you were taking one of these from a misdemeanor to a felony.
It's going to be in the code section on page 4.
Page 4.
Commits these violations. What it does, Representative Jackson, is I was reading, it's taking all those, like the reckless stunt driving, passing a school bus, and all this is during a chase. It's changing those penalties, going from a misdemeanor and making them an automatic felony.
The blue light too?
Yeah, yes, sir. We've had the law of impersonating a police officer. It's been in code section. We're just, if you'll look at that last page, you'll see just blue light is added. It says to impersonate a sheriff deputy or trooper agent, Georgia Bureau of Investigation, agent, Federal Bureau of Investigation, police officer, any other authorized law enforcement by using a motor vehicle or motorcycle designed, equipped, or marked as to resemble a motor vehicle or motorcycle. We're adding that blue light in there. If somebody puts a blue light in a vehicle to represent an officer of the law.
Thank you.
Representative Taylor.
Thank you, Mr. Chairman. I wanted to thank the author for bringing this bill. A year ago, we lost an officer in South Georgia as part of a pursuit that went bad. And this will protect not just the officers, but those that are fleeing. They also lose their lives also in this. So I think it is something good. Thank you.
Thank you, Mr. Chairman. I apologize. We have 2 meetings. Some of us have 2 meetings at the same time. So it's kind of hard to split ourselves. But thank you also for bringing this legislation, because I travel up and down I-20 all the time, and that's straight road, but I have seen police officers trying to catch folk. And it's very dangerous, and it makes me very nervous because I could have been a fatality in that. So, but my question to you is this. We're giving them a lot of chances here. So we got the same person can flee 1, 2, 3, 4 times?
Well, the penalty gets stronger each time and gets in that pocketbook a little bit more each time. We have to make this, it's a statewide bill. And so you look at what's going on in Atlanta, there's a no chase policy that the city of Atlanta has right now. So the State Patrol is working the streets, the interstates, and the Nighthawks, they work the whole metro area. And they have a South Nighthawk team, and do y'all have a Central Nighthawks also, and a North Georgia Nighthawks. So throughout the state, these teams are working, and they have specific dates that they do work, and usually are 10 to 12 hour nights. And they're out there they're working on impaired drivers. There's also other groups of the State Patrol that's out there working on speed, but anytime you're working for the impaired drivers or controlling speed, if you get that bad criminal out there, they're going to run. And it happened to us. The 2 nights that I rode, I think we got in about 4 or 5 chases between the 2 nights. And of course, that was just the car I was in.
Mr. Chairman, a follow-up question. So my question is, when does the Nighthawks know when to pull back where it looks like it might be dangerous, or it might end up being of fatalities? Do the police officers know when to pull back? Because I know they're on the radios calling up ahead, and everybody is in the chase. But when do you know to pull back?
Well, that's
So
going to be
that
up to the
officers
department's discretion. I'm sure they have policies and guidelines that that they use. Fortunately, in the city of Atlanta, the APD does have a helicopter that the State Patrol uses as part of a tool, and it's a great tool because one of the nights that I rode, one of the chases we were in, that we could follow that car, and you don't have to, get in that pursuit as much. But we ended up catching the guy because of the helicopter.
Okay, well, thank you, and thank you. Maybe by increasing the fines, that will slow them down.
Well, just sending a message, and we have to, the penalties, I mean, this is something we were looking at, that they weren't stiff enough. And the main part is, so what we did with the school bus is changing that from the misdemeanor to a felony. You think about the dangers when you're in a pursuit and you're passing school buses or going up on sidewalks or you hit another car. This puts a little bit more teeth in that it may be your first time, but if you do any of those other penalties, that it goes from a misdemeanor to a felony.
All right, thank you.
Yes, ma'am.
Any other questions? Thank you, Representative McDonald. You got one more? I'm sorry. Representative Holcomb?
I do. Thank you, Mr. Chairman. One question that I have is, I understand the concept, which is for those that are truly purposely and deliberately not following instructions that are clear and then flee and potentially put people into danger. What about the situation in which a person or a driver may not feel comfortable immediately pulling over and wants to pull over in a place that's safer, like wait until a gas station or something like that? It seems to me like that person could potentially still be charged with not pulling over, or am I wrong on that? In other words, what's the state of the law, the flexibility for a driver to drive a little bit further to a place where that person may feel safer for the interaction with law enforcement? Or is it just you have to stop immediately? Do you know what I'm asking?
There's no law that says you have to stop immediately, but we all have seen people when they stop in probably the wrong place when they're being pulled over. I mean, I think the officers use discretion of safety. A lot of times they'll even get on their loudspeaker PA system and ask somebody to move over to a safer area, but sometimes people just stop and freeze up. I mean, even I get nervous I get nervous. I don't get blue lights behind me often, but when it has happened, I mean, I get nervous as heck. I mean, even though I'm like, what did I do wrong? But you want to pull over in a safe area, and I think officer's discretion, and as long as you don't do anything reckless or try to elude an officer, if you speed up, and this going to be something that they're going to discuss with that person that is being pulled over.
Okay. My other question is, what do you think the likelihood is that the people who are doing this will know these fines? In other words, that it would actually have an effect of changing behavior. Do you think the people, if we were to pass this, would have an understanding that we changed the fines from $500 to $1,000 or the time in jail from 10 days to 30 days?
When they get pulled over, they'll get it, and they'll get it the next time, and then the next time. I mean, it's up to us to know the laws in Georgia. And, they have a network out there. A lot of the people that are doing the eluding the officer, especially in the metro area, it's a game. The guys on the motorcycles, it's fun for them, and so they talk. They'll know. You get in people's wallet, and you keep people away from their families, they'll think twice.
Okay. All right. Thanks.
Yes, one final question relating to how folks will know about the fines. So are we going to use and this is I'm asking this question for parents to let their children know. Just to piggyback off of Representative Holcomb, will we be using the highway sign billboards to say, hey, running from the police officers, or
I would hope not. I hope we would not have to.
Fines have increased to $1,000 if that's a deterrent, or
I would hope we wouldn't use the signs for that. I mean, I think that's a waste of information to people out on the road that we're having to talk about this, that we're even having to do this. People shouldn't run for law enforcement, period.
I know they shouldn't, but they do. So
Well,
I'm
parents should need to discipline their kids a little bit more. And I think this is, it's up to the parents to know when the kids are learning to drive that they know the law and the penalties if you break the law. But I don't think we should be using our signs, highway signs, to be talking about this issue.
Well, Representative Donald, all I was just asking about is the education piece.
Yes, ma'am.
Educating the public about the fines increase.
Yes, ma'am.
I know what we should be doing as parents, but all parents are not doing that. So it's about educating the public. That was the reason I asked.
Yes, ma'am.
Okay.
Thank you, Representative. Any other questions? We have a couple of guests that have signed up. So Representative McDonald, we're gonna let
Okay,
them
thank
come
you.
and speak
Thank
to
you,
it.
committee. Appreciate everything.
Robert Smith.
Good afternoon. I'm Robert Smith. I'm the General Counsel at the Prosecuting Attorney's Council. Thank you for the opportunity to address the subcommittee. As to House Bill 216, I want to give you an answer and also want to make an ask, if I could, of the committee. As to the answer, specifically to Representative Holcomb's question, it comes to us in a case called King versus the State, which talked about, in that instance, the motorist was blue lighted and that instead of stopping, continued on for 0.7 of a mile. But it wasn't just the fact that they continued on, it was the fact that the motorist bypassed several safe locations to stop. And that's what the court found, that there had to be evidence that there were safe places, and the motorist chose not to stop. They bypassed that and continued to keep going. So that is a function of law enforcement and an obligation that the prosecution must prove if someone is not bringing their vehicle to a lawful and complete stop when directed to by law enforcement, that there hasn't been a safer place to do it. And for those in the metro area, it's kind of easy to find places like that because there are plenty of places to stop or find a good place that's got a street light. In the more rural areas, might be a little harder to come by. So there's not a hard, fast rule that if you don't stop within a certain period of time or a certain mileage, it's inappropriate. So hopefully that answers your question, sir. Now the ask I have is that if you look at House Bill 216, and I'm working off of LC 393124 EC, and I want to thank the sponsor as well because I've spoken with him about the change I'm going to ask of this and the amendment I'd like to propose, and specifically at line 79. Right now, to commit the offense of felony fleeing, the only way when it involves driving under the influence is if there is a test of the person's bodily substance and it comes back at 0.08 or greater. It does not reach someone who is under the influence of drugs. It does not reach someone who's driving under the influence and is less safe. And it does not reach someone who's driving under the influence of alcohol and drugs. It only reaches those who are driving under the influence of alcohol, and there's been a test administered, and that test shows greater than 0.08. So I would ask that at line 79, that be amended, striking the word paragraph, striking 5, and striking of. So it would simply read subsection A of Code Section 40-6-391. And the reason why is that this body has created a DUI statute that provides 6 different ways, and we can have a debate and further discussion about the 6 different ways. But our DUI statute is 391A 1 through 6, and I'd ask this committee to make that amendment to allow felony fleeing to apply to all motorists who are driving under the influence, rather than simply the ones who have alcohol in their system and have been tested.
Do we have any questions on that? Do we need to entertain a motion that we? Do the amendment second, but we'll do a motion on the bill first. We need a motion and a second. Yeah. And then we'll do the amendment after we do the bill. Is that correct?
If there's any questions, I'll stand for questions.
Okay. We got one question.
I was checking with the author of the bill. If he's amenable, is this a friendly?
Yes, ma'am.
Okay, thank you.
We discussed it.
Thank you for your time and consideration.
Okay, thank you. We have a motion.
I know I'm out of order. I walked in at 1 minute after the hour and I didn't get on your sign-up list. Would you mind if I switch to the?
Well, we got one more. Are you Miss? Yes, come on up.
I really appreciate your accommodation,
Will
Chairman.
you introduce yourself for us, please?
I will.
Uh-huh.
My name is Maisie Lynn Girton. I am General Counsel and Policy Advocate for the Georgia Association of Criminal Defense Lawyers. Some of the concerns we have about House Bill 1216, frankly, are with the current law and have precious little to do with what Representative McDonald is asking for here. It ties to what Representative Holcomb was asking about earlier, and that is deterrence. This is one of the very few, if not the only, that I can think of moving violations in our code that already has a mandatory minimum 10-day incarceration sentence coupled with a fine. And these are not small fines. Already today, it starts at $500, and of course, we know about the increases that are happening today. When someone is incarcerated, the chances that they will lose their job, lose their home, lose their car, even if it's only 10 days, and under this bill, the minimum would now be 30 days, those are very real consequences that happen. And so then saddling people with an additional mandatory fine on top of that, it's going to be pretty difficult to actually receive that fine. In addition, the code section currently disallows any kind of probation. You can find this at lines 26, 34, and 43 as a mechanism for paying off that fine. And that is the traditional way that people do pay fines in our court system. They are assessed a fine as part of their punishment, their sentence, and then they're put on probation in order to pay it, which then, of course, as you might know, incurs an additional probation supervision fee on top of the fine, but that's for another day. So the code section disallows probation for paying off the fine. But then if you switch over to lines 55 through 59, appears to allow the court to impose a hardship exemption so that such person could pay the fine off over time. It's just incompatible, and this is current law we're talking about. And so since the code section's open, we wanted to bring it to your attention that there is this apparently technical dissonance in this code section with respect to how someone would be able to pay off this fine on probation, given that these are mandatory fines under this code section. I'd like to turn to the new felonies that are laid out in House Bill 1216. And these are the felonies that are found, they're part of now the new subsection C, that begins on line 65. Several of these additional acts, for instance, operating a vehicle in excess of 20 miles an hour, striking or colliding another vehicle or pedestrian, these are felonies today. Of the violations that have now been added to this code section, the first one under C5A is code section 40-6-144. That does involve when a vehicle emerges from between two buildings. That's part of that code section. The other part of that code section is if someone is riding their bicycle on a sidewalk. I find it difficult to believe that it's worth felony punishment in our state for someone to flee law enforcement on a bicycle. That's a policy decision for you all to make, but please realize that's what you would be doing. This would be elevating, if a person above the age of 12 happens to be fleeing from the police on a bicycle, it is now a felony under this bill. Similarly, Representative McDonald mentioned the school bus passing. I realize it's a very dangerous situation, whether that happens in the situation of a police chase or just right now, if any of us were to do that on our way home today. However, the General Assembly has deemed that to be a civil violation. It is not a criminal violation today to pass a school bus in that way under 46-163. It's a civil penalty, it's a financial penalty. And you would be elevating what is now a civil penalty when coupled with fleeing to a felony. Again, that may be a policy decision you'd like to make. We just want to bring that to your attention, that's a pretty different situation than what we have in the law today. And with respect to my colleague, Mr. Smith's amendment, we would purport that we would say that the current law is sufficient, and potentially even raise the concern that the whole point of a DUI driver, the whole concern we have about them, is that they're not making good decisions on the road. They're not capable of making good decisions on the road. So now we're going to punish them again for making another bad decision. I understand the point here, but what we know is that deterrence is not achieved by enhancing penalties. It's simply not. The Department of Justice has issued, you can Google it and quickly, easily find lots of social scientists who have looked into whether or not increasing penalties, whether it's fines or incarceration, has any chastening effect. It does not. It actually has the opportunity when someone's incarcerated to exacerbate their tendency toward recidivism. There's lots of reasons for that. In some cases, it's because people, frankly, learn how to commit crimes better when they're inside with other people who've committed crimes before. There's also the reality that the collateral consequences of having ever gone to prison, that it's hard to get another job, it's hard to get back on your feet, and a lot of people end up in the cycle of poverty and crime simply because they have no option, no way out. Certainty is what has an impact on deterrence, and certainty happens when people know that there's a likelihood of getting caught, and they know what the sentences could be. That doesn't happen. It's what Representative Holcomb was mentioning. People are not aware of these punishments. And even if they were, unless the idea that they would be caught and prosecuted and sentenced in that way is certain, it's not going to be a deterrence factor. The other thing I think it's worth noting with respect to crime is that a person's age is a powerful factor in whether anything deters them or whether they recidivate and to commit additional crimes. And what we know is that as people age, their likelihood of committing crimes decreases. And so when we're applying the same sorts of rubrics to everyone, we are missing out if we're going to incarcerate and pay state dollars to punish someone or incapacitate them as they age. The final concern we have about this legislation is with respect to the portion that's found at lines 81 through 83. In the current law, although there are these new felonies laid out in House Bill 1216, under the current law, there is currently a way you can commit fleeing and it be a felony, and it's now found in subsection, I think it is still subsection C. But the difference here is that today, the court has discretion in how she sentences someone convicted of felony fleeing. Today, it would be punishable by a fine, imprisonment, or both. It is our position, and you will hear us say this every time we come into your committee hearings where there are mandatory minimums or these prescriptions for the court tying their hands on how they sentence someone, to ask you to please leave this kind of discretion with the judges. You're not taking away, if you, basically by striking or both on line 83 and adding and on line 82, you are making it impossible for a judge to decide between a fine or a prison and requiring them to do both, which is what's happening already in the misdemeanor scheme, which we also don't love. But the judge is in the best position to know what happened in that case. And as you might imagine, we've already talked about today the different ways fleeing can look or happen. It looks different in a place where you can pull over safely or not safely, or what other crime was an issue, right? If you're fleeing from something like shoplifting versus fleeing from something like an armed robbery, there are lots of different factors the court might want to take into account And the court might realize, you know what? This person does need to go to prison. Right now, they could go for up to 5 years. They need to go to prison for all 5 years, but I know they're not going to be able to pay a fine when they get out of prison for 5 years. So I'm not going to require a fine of them. But under this bill, you're going to make it impossible. They're going to come out of that prison term, now potentially 10 years in prison, and be saddled with a fine that's at least $5,000. I couldn't pay a fine of $5,000 today if you asked me to. I certainly couldn't pay a fine of $5,000 if I spend 5 years in prison. So we're simply asking you to leave the discretion with the courts so that they can make that decision if it really needs to be both, because maybe the person in front of them can do that, pay that fine and serve that time, and that is a right, equitable punishment for them.
All
But
right.
generally speaking, it's not going to be. When 95% of the people that are processed through our criminal court systems live in poverty, and that's part of why they're there.
Okay.
Thanks for hearing from us.
Representative Taylor, you got a question?
I do, a couple of things. You talked about going around the school bus.
Yes.
You talked about going on the sidewalk.
Yes.
That's only if they are fleeing the police. They're
Yes.
making more danger to that pedestrian or the children on that school bus by fleeing. All they have to do is stop and not flee. Now, I get it. We're all seeing a lot going on right now with criminals, and I can tell you, there have been criminals that went away on a bicycle.
Absolutely.
So at what point would you say we don't pursue? At what point do we not prosecute? At what point do we let them continue to commit crimes? This way, they're not going to be out the next day. This is something I think, and I've heard from the public, they are not happy with how our public safety is being abused right now. So they have told us, at least me, they want to see some teeth out there. They want something to happen to those that are committing crimes. I get what you're saying, and I do know, and I've had constituents with people that have been in prison. The problem is, at what point has the public had enough? Thank you.
May I respond just briefly, Chairman?
Yeah, very briefly, okay?
I hope that you aren't hearing the sentiment coming from me that we expect people to not be prosecuted. That is not our position at all. We're asking for prosecution and sentencing that is equitable. Taking my lobbyist hat off for a moment, I'm the mother of a child that goes to school just down the street from here. I'm grateful, frankly, as an Atlanta citizen, that there's a no chase policy in my city, because just before the pandemic, the Georgia State Patrol chased a person off of I-20, and that chase ended at my child's school during school pickup. We are thankful that no one was hurt that day. I can't explain why that 17-year-old child fled from the police. I don't know, and I'm not trying to say that was right, but I know that the amplified situation that happened because of that police chase could have really hurt a lot of people. So there's a couple things in play here, right? There's policies around how and where we chase. That's secondary and separate from how we prosecute and punish them. So I feel like sometimes it's
Yes, ma'am.
easy to talk about them together.
Well, let me say this before I go to you, Representative Taylor. I'm real sympathetic to the criminal that's breaking the law. I'm sympathetic to them having a job and paying the fine.
Thank you.
But I'm more sympathetic to the victim of these crimes.
I understand that.
And I'm more sympathetic to the law enforcement that's risking their lives to try to stop them from causing someone to be killed. Now, see, I've had the opportunity several times, which is terrible, to go tell someone that their loved one's been killed in an accident like this, okay? So what I'm saying is, I see your point, but what the purpose of this bill is to try to deter somebody from doing it to start with. So when we get together with this, we got to make sure we're protecting the victim more than we're protecting the criminal. And sometimes we get that backwards. So I might have spoken a little bit more than I wanted to right then, but I have experienced that side of it. And I have seen the law enforcement put themselves at risk trying to stop someone that could potentially kill innocent victims like your child. So that's where I'm at on it. Let's go to
Thank you, Mr. Chairman. And I am very grateful that no children were hurt and your kids were safe. And I'm also grateful that the police were able to catch this offender and they couldn't do it again. It will take them off the road and you won't endanger more children. Thank you.
All right, let's move to the amendment. Representative McDonald, let's see what we need to do. Abby, help me here. We had an amendment that was talked about, and we want to make sure that we address that. Are you in agreement with that amendment, or?
Yes, sir, we are in agreement with
You-
it. We
you
met
are-
before, yes, sir, before the committee meeting to accept the amendment that was going to be proposed by them. We also, I just want to mention that we do have, the State Patrol, the Colonel, a Major of the State Patrol, and Sergeant Mooney are here, and any of these questions that were asked about pursuit and how they operate, I mean, they'll be willing to speak to the committee if the committee so chose.
Representative McDonald, does anyone would like to hear from me? Yeah, if one of you would like to come up and introduce yourself, we'll entertain some comments.
Good afternoon, Mr. Chairman. My name is Josh Lamb, and I serve as the Chief of Staff for the Georgia Department of Public Safety. I appreciate the opportunity to be here and would be glad to answer any questions that you may have.
Thank you for being here. Number one, do we have any questions? Do you have anything you could just share with us about the bill that you feel good about, or things that might need to be addressed?
Sure, I'll be glad
Okay.
to speak to it, and thank you for the opportunity.
Yes, sir.
One of the things we've seen as an agency, whether it be in Atlanta or if you watch the news, you're seeing it play out across the nation, but crime is out of control. Pursuits are one part of it. I do believe that a part of that is caused people see a lack of consequences for their actions. I think this bill goes a long ways in addressing that, and like so many have spoken out today, go to deterring it before it happens. I can't sit up here and tell you the punishment for every crime in the code book. I don't think anybody could. But I think this goes a long ways in establishing that the punishment for fleeing and attempting to elude from a police officer is very serious. There's still leeway in there for it to be a misdemeanor or a felony, but we're increasing the chances now. If you behave in a certain way, it's going to be felonious behavior. I think we all know somebody that makes a conscious decision to flee from police. It's just that. It is a conscious decision. They have decided to do that, and when it plays out in a manner like we talk about in the bill, either driving on a sidewalk, passing a school bus, driving over 20 miles per hour, I think that heightens it, and it should become felonious behavior. And I think that's what this bill does. And, of course, nobody wants to unduly punish anyone, and there's always going to be outliers to any code section or fine or any punishment. But I think this addresses behavior that needs to be addressed. We support it, and we're very much in favor of it.
Thank you. We have a question. I believe Representative Jasper.
Yes, sir. I just, maybe to you or the bill sponsor, but from what I, had a hearing this summer, Public Safety did, and one of the issues I think, when I read this bill, it's talking about any person convicted, on line 21. But the issue right now, I think, and I wish this addressed, is that when someone is arrested by you guys, taken to magistrate court, turned around within 8 hours, and back on the street, and the car engine's still warm, and back out doing it again. So then we're gonna have to work through this to get here. This guy is out, lady, whomever is out repeatedly over and over again. Have we thought about how do we address that? I mean, Mr. Chairman, that's my frustration here, but we have to wait for the court to, if they work through it, to get to this point. And I think the people who live in the metro area in the city, that's their problem. I mean, and I think it's yours. I think we share your frustration and I'd love you to address that, but this bill doesn't address that, but that's the problem.
It is a problem, and I don't exactly have the answer to that, because whether it's with this crime or any other, of course, judicial process is a thing, and we don't want to deny any one of that, but it is a problem when we have repeat offenders that just keep offending. And I think that is one thing that you see when you look at this bill is we're trying to address that. We want to address repeat offenders. We want to address people that are doing this time and time again, and we want to put a serious consequence to it. I think what you're mentioning is always going to be a problem whether it's this bill or any other, but I think this is the best step that we can take and put forward legislatively to try to deal with it, in this case, dealing with fleeing and attempting to elude.
Representative Frazier.
Yes, sir. Thank you. Do you think that with the increase in the fines, that this will be, I know we're trying to deter them, but the repeat offenders, we have to really kind of wait and see how this is going to work if we can pass this legislation, and the timeline we're looking at. I don't know when offenders repeat. You know, they might do this 1 month and then next year they might do it. So do you think the increase in the fines will deter this to a degree where?
Let me kind of spin it on its head and say that I think by not increasing it, it won't deter it either. So what I do think happens is if we do increase it, one, messaging is a thing, and you mentioned that earlier. Maybe we can message that out, whether it be social media or some other avenue that we do. That is important. We want to get the message out. We want people to be knowledgeable of what it is. But I do think people know, regardless of whether they know exactly what the code section is, they know that fleeing from a police officer is serious. They might not know the precise definition of the code section, but they know that's a serious offense with serious consequences. I think by putting this forward, I do think it helps address those repeat offenders that we're talking about. Because once they're charged with it one time, whether they knew about it before or not, they're going to know about it then. Not that they didn't know that it was a serious offense, but they're going to be more aware once they're arrested once for it, and hopefully they're going to be much less likely to repeat offend, as we've mentioned. So I certainly think it helps, and what I do know is that if we don't make a change, it's certainly not going to deter it. And I think this, again, is the best step that we can take forward in hopes of doing exactly that.
Thank you.
Yes, ma'am.
Any other questions? Thank you.
Thank you
so
for your
much.
time.
Anyone else like to speak to the bill? All righty. No more questions. I think you will entertain a motion. Do I have a second? We have a motion? Have a second. Discussion about the amendment. Lauren. Excuse me, Representative McDonald. If y'all could go back over the amendment with us, and we're going to discuss that. We have a motion and a second. We're going to do the motion for the amendment, and then we'll go forward.
And once again, I'm Robert Smith from the Prosecuting Attorney's Council. The amendment is on line 79. It would strike the word paragraph. It would strike the number 5 in parentheses, and it would strike the word of. So it would read sub, and then you'd capitalize the S in subsection. So it would read, so line 79 would now read parentheses F, subsection parentheses A of code section 40-6-391. And the justification is that way it reaches all of the ways in which someone can commit DUI rather than simply the one way that's listed.
Thank you. Leg, you're good? I just want to make sure everybody's good. Do I have a motion to accept the amendment? So move. Second. Okay. All in favor? All right. Carries. All the noes? All right. The amendment's done. Now we'll vote on the bill to move out of here, out of Committee A. Subcommittee A. I have a vote. We'll all say aye. Like sign opposed. One opposed. All righty, the bill carries. Thank you very much, Representative McDonald. All right, we got one other order of business here. We have Representative Buckner. It's a hearing only on House Bill 1281.
Thank you, Mr. Chairman, ladies and gentlemen of the committee. I'll try to go through this because you've had a laborious committee meeting already. This bill started back with the past administration, the Governor Deal's administration, and it almost made it to the finish line. It was over in the Senate. It had passed out of the House, and it was the last night, and there was some interesting things going on in the Senate that night. They drew a line and said no more bills behind that, underneath that line, and it was underneath the line. we've introduced it several times since, and so we're back again. Let me just begin by saying that this started for me because of a situation in my district. It is a fairly simple bill, but let me go tell you what the bill does, and then I'll tell you the story, and it'll hopefully make sense why we want to do what we want to do. The essence of House Bill 1281 is lines 30 through 34, where it strikes that after 5 years have elapsed from the date that a person's involuntary hospitalization information has been received by the Georgia Crime Information Center, the center shall purge records and such information as soon as practical, and in the event of a purge of the records within 30 days after the expiration of the 5-year period. What that means is that if a person has been involuntarily committed to one of our mental health hospitals, 5 years after they leave the mental health hospital, the computer purges their name from the criminal background list, and they are then able to go and purchase a gun. The way this played out in my community, there was a person that was well known in the community for having some issues, and there had been numerous 1013s taken out on this person, and they were ultimately committed to the mental health hospital. Upon leaving the hospital, a while after that, that person entered a store that sold guns with the intent to buy a gun. Very well known to the community and well known to the shopkeeper. The shopkeeper knew her behavior at that particular time was a little unsettling, and the shopkeeper said, I'll have to run a background check, fully expecting that the person wanting to purchase the gun would be on the list. When it came back, that name was not on the list. The shopkeeper called the local sheriff, who also knew the person and was surprised that the name wasn't on the list, and did some checking, and that's when we first learned that the computer automatically purges those names 5 years after they leave the hospital. I don't want to name the county or the store or anything like that because I don't want to impugn anybody, but they got with the family and worked it out, and they did not sell the person the gun. That is not a usual customary way to do that. They usually go along with whatever's on the criminal background report. And in a larger urban city, instead of a rural community where everybody knows everybody's business, the gun would have been sold. What that community has asked me to do several years ago, and I have been working on diligently ever since, is to make Georgia remove the 5-year automatic computer purging. This is the only forfeited right that has no process to reinstate the right. It is done by a computer. If you are put in jail and you want to get back out and vote, you have to go through a process. And this is much more serious even than voting. I mean, it can cause harm to themselves or to others. So that's the story, that's the history, and I guess what I would also add to my presentation is that we are the only state in the United States that allows this. Every other state has a process for people to go through to get their gun rights reinstated. When the criminal background listing was started, it gave a range of more than 5 years after leaving the mental health hospital, and we chose 5, which was the least amount. And we're the only ones that are using the automatic purging right now. The other thing that I would say is that I think one of the officers said it a minute ago that with the last bill when he said that deterring before it happens is a good policy. And I kind of think that applies to this bill as well. I'd be glad to answer any questions that I can, and I would appreciate your favorable consideration at the appropriate time.
Let's see, Representative Taylor.
Thank you, Mr. Chairman. If it's left on the list, and because your name is on the list, does it identify why you can't get the gun? Or if it's if it's been 8 years or 10 years, or does it just mean they cannot purchase a gun?
And it means that they would not be able to purchase a gun without going through a reinstatement process.
Okay.
It's not keeping them from ever having one, it's just saying that they would have to go through a process to have the right to get one.
Do we have that process in place somewheres in statute that says what the process is they would have to go through?
Probably not as clear as it needs to be, and what we found when we have talked about this every year is that most people feel the best process would be for us to have the person go back to the court that committed them and reassess the situation and allow for them to be able to purchase the gun.
Okay, could I follow up? I also had a question of where it says the record of, and you struck out Georgia Crime Information Center to just center, and it's also, you know, on the back where it says the Georgia Bureau of Investigation, and you just put Bureau.
The
Is-
Legislative Council did that. They said they were making it uniform with the rest of the code.
Okay.
I didn't
so-
have anything to do with that.
All
I
right.
mean,
Thank you.
I didn't do that.
I'm glad you asked that question, because I had the same. I didn't know what that was.
Actually, I did too, and I have a memo from them explaining that that's what they did, because I
Yeah.
wondered as well.
Abby she filled me in on that a little bit, so I appreciate that. There you go. Anybody else have a question? I kind of want to go along, let's see, we do have one, Representative Frazier.
Yeah, well, Mr. Chairman, I do, because I'm kind of concerned also about folks that have been admitted or have mental health illnesses and have been, a lot of them have had it all their lives. And it took me back to my hometown, where I'd actually had someone that was like that for years and years. They got the help they needed, and they were able to, Representative Buckner, go out and after a few years get a job and start, you know, being back in society. And that was because of the medicine that was available over time. Mm-hmm. And then they're living by themselves, and they needed protection. So they were never able to get a weapon because they were
On the list.
on a list. So with this being taken off the list, I mean, they're being purged off the list now. I say they are okay, but that doesn't mean that they are. And that process that you were talking about is not in concrete. So how does she get this process if she doesn't have, if she can't go back to that court, and that's been 10 years ago? Mm-hmm. What's the process now? I know you were asked that.
Right.
But is there any way that she can?
Now, if she has not got any problems at the end of 5 years after coming out of the hospital, she's eligible to go buy a gun. Her name comes off the list now automatically by the computer.
Well, this is not, she's not in Georgia, so she's not on the list. She can actually get a weapon, but I'm just saying.
Right.
There was
But
a
in
time when
Georgia,
she couldn't.
and I come from the healthcare background, and the thing about the 5 years is particularly troublesome. If it were longer, maybe that would be better, but the 5 years is particularly interesting with mental health, because many times there are relapses.
Yes.
About that time. People decide that they are doing fine and don't need to take their medicine anymore. And that's just a really awkward time for us to say you automatically rotate off of the list after you've left the hospital.
Yeah.
Thank you, Representative Frazier. Again, this was a hearing only.
Yes, sir.
Could we look in to see if there was a pathway for somebody to?
Yes, sir. And I purposely left that out because of the fact that there was
Yeah.
so many different ways. Now I've got the research to show that most of the states that have a pathway forward are referring the people to go back to the court that committed them, and it's working out rather nicely.
Good.
So I'm more than happy to do that, but I just was waiting to see how far we could go.
Yeah. Well, I'm glad you clarified some things for me, because there were a couple of things I didn't quite understand. But I do see that, and I see your point, but I also see where there's instances where somebody did something, but they shouldn't be held for the rest of their lives. But I agree with you that we need to look at the time limit maybe. I think DFAX is 7 years. So maybe we could look at some of that, and then also look at a pathway. So
I definitely I'm not opposed to them, but to me it's just a kind of incongruous that you have to have a process to get a driver's license. You have to have a process
Yeah.
to vote.
Yeah.
Why wouldn't you have to have a process for this?
yes, ma'am. Sounds good.
Thank you. I appreciate the hearing.
Yes, ma'am. Go.
I will
Rep-
get in touch with you with some amendments for the process and for possible other year options.
Yes, ma'am.
Okay,
Yes, ma'am.
I'll do that.
I think we have one more question.
Oh, I'm sorry.
And also, Mr. Chairman, I think that since this is old and antiquated, and we're the only state that's doing it, when you do come back, to have that alternative, like you just said.
Yes.
Okay, so we're taking this out, and so what are we replacing it with?
Gotcha.
That will conform with all the other states, and because it seems to be working in the other states, because the thing that we have now is time, because mental illness doesn't have a purge date.
Right.
Thank you.
All right, thank you.
Thank you.
Thank you, Representative Buckner, and we are adjourned.